Hi, everyone. I'm going to go ahead and start. Thank you all for joining us here today, either in person or on Zoom. Okay, so I'm happy to introduce our Executive Director, Abby Brenneman.
Hey, before you go away, Megan, I just want to say, Megan did this whole thing, okay? So all these great PowerPoints you're gonna see, there's QR codes on there where you can access all the forms that we're gonna be talking about, the materials we're gonna be discussing, all the everything. Megan set it up and we just did what she told us to do, okay? So, thank you, Megan. Great job. Okay. So our first panel today is improving the court fee waiver process. Filing fees can present significant barriers for self-represented litigants and for low-income people in general. But fortunately, we have a fantastic rule that allows for indigent Arkansans to request a fee waiver. This is Arkansas Rule of Civil Procedure 72, titled Suits in Forma Pauperis, and it was established by per curiam in the 1980s. And it's been amended a couple times since then. And so today we're going to be talking about that process, what it looks like now, and what maybe it could look like in the future. But we're also going to stray away from that a little bit and talk about self-represented litigants and affordable legal services and access to justice in general, of course. That's our thing, right? So like I said before, there are QR codes on these slides where you can take a look at the stuff that we're kind of talking about. And I think the Wi-Fi is, I don't think there's a password here, right? AMFA guest, that's the one, if you need a connection. All right, so we've got a diverse group of panelists here, very diverse perspectives from legal aid, judicial administration, from community advocacy, and the bench. And this panel is moderated by moi, Abby Brenneman. All right, so to get to our panelists, first off, we've got Judge LaTonya Honorable. We're honored to be joined by Judge Honorable, who brings a behind the bench view of how fee waivers are evaluated in practice. Judge Honorable has led innovative programs in her courtroom, such as amnesty initiatives for felony warrants to reduce procedural burdens and create more stability for individuals navigating the justice system. Before taking the bench, she worked as a helpline attorney with legal aid, and she was also a fair housing hearing officer, excuse me. And a long-term leader in the Arkansas legal community. We've got Tabitha Lee over on the y'all's far right. Tabitha is a community advocate and the director and founder of the Delta Justice Center. She is also on the board of Winthrop Rockefeller Foundation and on the board of the Access to Justice Foundation. While she doesn't use fee waivers in her practice, many of Tabitha's clients are part of the ALICE population, asset limited, income constrained, employed. And so her practice is built around affordability. So we're going to be hearing from her and what she has to say about all that. Kendall Lewellen over here on your left. Kendall is a fair housing project attorney with Legal Aid of Arkansas. She regularly works with clients who rely on fee waivers to access the courts. She has served the legal aid community in many capacities since her first year of law school. From pro bono coordination, grant writing, legal representation in housing, family law, and public benefits cases to management. She also previously served as a managing attorney for the Center for Arkansas Legal Services, and she was a staff attorney for the Fort Smith Crisis Intervention Center. She's also an active member of the Access to Justice Commission. And Kendall has been instrumental in helping to produce some of the interactive forms that we have on our statewide website, fact sheets, and pro se resources and legal information in general. Okay. Thank you all for being here.
Thank you.
All right, so to start out, I thought we'd get warmed up with some sort of introductory questions, starting with Judge Honorable.
I think she said that because I'm the talker.
Maybe. So all right, so you used to be a helpline attorney, right?
Yes.
And I don't know that everyone is super familiar with what a helpline attorney does. I know Karen is super familiar. So to give us a little bit of a breakdown of what that's like.
So I proudly worked for legal services from 2008 to 2013, and then again from 2015 to 2022. And all of that time, I was a helpline attorney. I was in private practice during that time. And a helpline attorney, we did a lot of different things, particularly depending on if there were any special projects going on. But essentially, we would monitor the phone lines when they would come in after potential clients had been screened for qualifications for our services. And once that happened, then it would then be forwarded to the helpline attorney to assess whether or not there was any type of legal issue that we would be able to assist them with based on our priorities. There would be times when our priorities, I would say when there were special projects that we would screen for criminal record sealing, housing, special projects, programs, and things of that nature. And so it really allowed me to really get a good understanding of a lot of different legal issues. It allowed me to be able to understand how indigent clients heard things from a legal perspective, how they understood, and quite frankly, I would go so far as to say working at legal services as a helpline attorney helped me to become a better attorney because it helped me to be able to identify more with those individuals I was serving. And so it literally was an opportunity to see what issue you have, whether it fits within our priorities, and then whether we could forward that on to an attorney in legal services or whether we would send advice. And I really loved that part, even if they weren't able to be referred to an attorney, because it gave me an opportunity to use what I learned from them in terms of speaking their language. And it gave me an opportunity to arm themselves with information that they would then be able to use in their self litigant representation.
Yeah, and I think one of the things that's really unique about the helpline is that it is this sort of like, you get an opportunity to see kind of the trends that are happening. So it's a real opportunity to solve some problems on a larger scale.
Absolutely. And I will say that many times the individuals that would be calling, sometimes they didn't really know what they needed, but you could tell that they were disarmed and felt a little more at ease just by having someone to talk to and figure out what they needed to do. So it was super, super helpful, professionally and personally for me.
All right, so I've got one for Tabitha. All right, so you also have experience at Legal Aid, and now you run your own law firm, the Delta Justice Center. What inspired you to build the Delta Justice Center, and what's unique about your law firm?
That was a lot of questions. Okay, so yes, I worked for the Center for Arkansas Legal Services from about 2017 to about 2018. I worked in special projects, which was mainly criminal record sealing and some veterans benefits cases, and a lot of criminal record sealing clinics around the state. So that was the clinic style model, was a lot of my workload, and it taught me a lot about what people need, what they can get out of that type of clinic, what doesn't work so well, what type of areas of law doesn't work so well for that. For example, in my experience, doing estate planning or any sort of advanced directives or anything like that is much more better suited for that type of clinic model. Criminal record sealing is near and dear to my heart. That's my main practice still today. I have background with a circuit court judge who did 100% criminal law. And so I got to sit in his courtroom for 2 years and learn everything about that, work with public defenders and prosecutors and just see so many different things, including my colleague here. And so I just that's one of my main areas, that I focused on. One of the main areas that I've ever worked in law that is a small area of law that has a huge impact in the person's life, going forward. But it's harder, in my experience, it's harder to let a person go with those type of documents without any further direction that has to deal with the prosecutor. Prosecutors are always, it's an imbalance there. The prosecutor has a lot of the power. The person doesn't have any more knowledge going forward. Unless, they'll come back, they'll call the attorney if they have that option. And so, just kind of with that experience, I moved home. I went home to get married. And that brought a lot of conflict to my practice because I'm married to a circuit judge in my district. And anywhere that I would have worked down there would have had a lot of conflict, whether that be child support, that's so I live in Southeast Arkansas. I'm based in Monticello. I'm born and raised in Dermont, Arkansas. There's not a lot of attorneys down there. There's probably one attorney for every 1,000 to maybe 2,000 people. It's a very small number of attorneys in private practice. So that kind of made me want to go that way. The way I got my law firm started was a sub-grantee from Neil Seeley at Arkansas Community Initiatives gave me a sub-grant from Winthrop Rockefeller to do work for Alice Communities, which is basically one step above legal services. They can't qualify for legal services based on their income, but they still don't have enough income to afford legal services. So that's the population we're talking about. But really, there's both in the area. So I got that sub-grant. They gave me about $5,000 to seal criminal records for people. I did that. I worked on that project for my first year or so in practice. And then was able, so it's kind of, it's a PLLC, but I do get some grant funding. I need to look at this. I had some babies and then COVID happened, so I need to look at my operating structure, but that's how I'm able to help people is I'm in private practice. When I'm not working on a grant basis, I still have, what I consider for the area to be affordable legal services. So I take that into account. This is a question she might get to later on, but I do a lot of payment plans. I do a lot of unbundled document preparation, even though I literally still will walk them through the whole thing and not just let them go with the documents because I know the courts in our area. So it's just a lot of experience went together and, it seems there was kind of a plan and I'm also just kind of doing stuff. But it's just kind of working to see, because I'm from the area and I'm trying to serve the area and find ways to have people are going without their legal services met. They will just not deal with it at all. And then it gets to a point where whatever it is really an untenable situation. There's nothing that can be done about it anymore. And so even just trying to get them started or somebody to talk to, I refer people to the helpline all the time. Sorry, guys. But I send people to the helpline all the time because I don't practice in those areas. I don't feel comfortable giving that, but everybody needs advice from every area in that area. So I know we're getting there. We're going to talk about directories and stuff, but just trying to create more resources because in that area, you really, really see the need and the lack of attorneys together.
Appreciate that. Yeah, I think the latest Justice Gap study from the Legal Services Corporation says that 92% of people nationwide, low-income people, do not have adequate or any legal help for their problems. So that tracks. Kendall,
Hello.
you're next. Okay, so can you give us a general idea, or actually, wrong question. Can you tell us a little about what drew you to legal aid or to housing, more specifically? And then if you have any client stories that you're allowed to share that maybe represent or kind of state or show, this is why I do this.
Sure, of course. So I went to law school with the goal of becoming some sort of public interest lawyer. So I knew that I probably wanted to work for a nonprofit or a government agency of some kind. And initially I I clerked for the Center for Arkansas Legal Services the summer after my first year of law school. I loved it. And I've been doing some sort of nonprofit legal practice ever since. And a funny thing is that these days, my main area of law is housing. But in law school, I did not like property law. I wasn't especially good at it. But when I was working at Cal's in law school, I sort of saw how it affected the lives of our clients, and I saw it a lot differently. You can't really flourish as a person if you don't have a stable place to live. Housing is so important, and and a big thing about me is that I love like civil procedure. I love to make procedural arguments and things like that. And some people might think those are just technicalities. I don't see it that way. I see them as really important safeguards to make sure that people get due process before they lose things that they care about, like their kids or their homes. And so I love housing, and I love that I get to make a living doing this kind of work. So I was thinking about if I had any cases I could speak about, and just an older case that I worked on was this woman called, and she was kind of frantic. She was getting locked out of her home that day by the sheriff's department, and it sounded like an eviction. She was real upset. And I looked into it, and it actually wasn't an eviction at all. It was like a nuisance case, and the local prosecutor, this wasn't around here, but the local prosecutor had filed a nuisance action because basically her neighbors were accusing her of criminal activity out of her house. And I looked into it, and maybe that was going on, but the only crime that she was charged with, I think, was like a misdemeanor drug offense. And so I got involved in the case. She had already defaulted because she didn't have access to a lawyer. She was a homeowner, by the way. She owned her home. But she didn't know how to represent herself. She lost the case, and she lost her house. And so I got involved, and we worked something out with the city to like fix her house up. She wasn't gonna have people renting out rooms anymore. And she went to drug court and got sober, and she really changed her life throughout the course of the case. But it just kind of hit home for me that if people don't have access to counsel, some really strange things will happen. And I'm so glad that there are legal services organizations to at least help with that, but the resources that we have are not enough.
I think that the other panelists were trying to tell me this earlier, Marisa, but I think I skipped over your introduction. So if I come to Illinois anytime soon, I owe you a coffee or something.
No worries.
All right, so this is Marisa Wiesman. We worked on that. She is the Deputy Director of the Access to Justice and Strategic Planning Division for the Administrative Office of the Courts in Illinois. All right, so she joins us from Illinois, and this is which is where she and her team oversee access initiatives across the state's court system, including operating a hotline. We'll talk maybe more about that later, supporting self-represented litigants, and in recommending administrative improvements such as updates to the statewide fee waiver process. Illinois has had a standardized IFP form, which they call it a fee waiver application, for over a decade, and is now beginning a process to reimagine what that will look like. So thank you, Marisa, and I'm sorry for skipping over you.
No, thank you. I'm thrilled to be here, and sorry I'm not there in person.
No problem. So I wanted to see if you could give sort of a general idea of your division's size and structure, and how that capacity supports your work.
Yes, absolutely. So as Abby said, I work in the Access to Justice and Strategic Planning Division of the Administrative Office of the Illinois Courts, the AOIC. So we, the ATJ division, provides the staff support to our Access to Justice Commission. So the Access to Justice Commission is a committee of the Illinois Supreme Court, and then staff at the AOIC provides support to the commission. So we have 24 staff in our division just working on access to justice issues. So we are pretty well resourced relative to some other states, which I think is a key to our success. And we cover a whole range of access to justice related projects. Statewide standardized forms have kind of been a cornerstone of our work from the beginning. But we also work on language access issues. We have a project specifically looking at access to justice in the appellate courts. We have a community trust committee that is working to build trust in the judicial system within the community. We have a remote access committee, a consumer debt committee. We have a network of self-represented litigant coordinators throughout the state that we provide support and resources to. We have a disability access program, and we also have 3 grant programs that we operate. In addition, as Abby mentioned, we have a statewide legal information and navigation hotline that I'm happy to provide more information about as we go on here today.
Great. Well, I mean, since you brought it up.
Yeah.
I would like for you to share who is eligible to use this hotline and how many people are receiving the calls or emails or text or however it works.
Yes. So a little bit of background. So our hotline is called Illinois Court Help. It is a free statewide hotline. It launched 3 years ago, almost exactly 3 years ago. So in those 3 years, we've served 72,000 people through the helpline. We have 13 staff, they're called court guides, who answer the calls. People can also text or email, and we monitor that as well. And anybody can call. So there's no, eligibility criteria. Any court user can call. We have attorneys and judges call with questions, which is kind of interesting. Obviously the bulk of the people who call are self-represented litigants. But it's, any case type, any legal issue. Our court guides are providing navigational assistance. So they are not providing advice. They are, helping explain how you e-file something. When the judge said file a motion, where can you find that form? That's the type of support that they're giving. They also connect to legal information and legal aid organizations and other referrals as appropriate.
And I guess I'll just go back and ask you a little bit, one of those introductory type questions. What is something what inspired you to focus your career on access to justice and strategic planning within the courts?
Yeah. Well, as I think a couple of the other panelists alluded to, it was always my intention to work in the public sector. So I went to law school with the idea that I would be a public interest attorney. My sister was born with disabilities, and my parents were great advocates for her. So it was clear to me from early on that we have systems and protections in place for vulnerable people in our society, but you kind of have to know how to navigate and work those systems in order to make them work for you. So before I joined the Access to Justice Division, I was a legal aid attorney for 15 years, handling the full range of legal aid cases that we tend to see. And then I had this great opportunity to come to the Access to Justice Division and work on a lot of the same issues, but kind of from a systems level, which is really exciting for me to kind of be able to look at the problems on a high level and say, what can we do across the state to address these issues?
Thank you. I'm gonna bring it back to Kendall for this next one. So at Legal Aid, how often do you and your colleagues end up filing for IFPs, requesting fee waivers, and what's that objection? Duplicate questions or what is
Compound
question? And what does this mean for your clients in their ability to access the courts?
So we help people file fee waivers fairly often. These days, I personally don't do it that much in my practice because I mainly represent defendants or people who are being sued. I still do it sometimes. I file some cases for plaintiffs and we request that the fees be waived. But my colleagues who work in family law do it quite frequently when people are, trying to get a divorce or handle some other child, family matter. And we used to do it quite a bit for record sealing cases until the legislature changed it to where those cases don't require filing fees at all. So I would say we do it quite frequently, and it's incredible. Fee waivers are incredibly important because, what, like $100 to $200 might not sound that might not sound like that much money, but if you make like $800 a month, $1,000 a month, or nothing, that's a huge portion of your income. And also your ability to access the courts and to handle your problems is so important. And without a fee waiver, you just can't many times.
And have you all noticed what have you noticed in how the petitions are handled in court? Is there consistency? Is there inconsistency? What are you seeing out there?
There's some inconsistency. In a lot of places I practice, when I file them, they tend to be granted, but it really varies based on where you are in the state. We do see a lot of judges who, if somebody files, it's a set of forms, but it includes an affidavit that the petitioner fills out about how much income they have, what their assets are, how much money they have. And some judges will pretty routinely set those cases for hearings, not on the person's actual problem that they're trying to file a case over, but about whether or not the person has enough money to where they should have to pay a filing fee. So, sometimes if it's somebody we're representing, we'll have to drive out, maybe an hour away and go to a hearing about whether or not this person can afford to pay a filing fee. And so that certainly happens. But there are two main ways that I see courts look at fee waivers. And one is like, is the person low income, or like, does the person have any income? And in some cases, if the person has any income, they're told, no, you should go pay the filing fee, but oftentimes, if the person is low income, it's simply granted and the case proceeds as it should.
Yeah, and I did work at Center for Arkansas Legal Services for a little while out of law school, and I did have a case where the judge did want to have a hearing on the IFP petition because the client inherited a little sliver of land in Hot Springs Village, which if you've looked at any of that over there in Hot Springs Village, they're like worth -$5. So we had to have a hearing on it, and the client had to drive 45 minutes from where she was living to go to court just for a 3-minute hearing. But I also had a lot of them approved as well. But Marisa, you guys do it a little bit different in Illinois. Can you walk us through how Illinois' fee waiver process is structured and what criteria is used?
Yeah, absolutely. So the eligibility for a fee waiver in Illinois is set by statute. And then there is a Supreme Court rule that implements the statute and actually sets forth the process for obtaining a fee waiver. So we're kind of working, with the statute and with the Supreme Court rule. So there are 4 ways to qualify for a fee waiver in Illinois. The first is that you're represented by legal aid. So that's enough. The statute and the Supreme Court rule allow the legal aid attorney who's representing the person in court to file a certification that says, we are representing this person qualifies for our services, therefore they qualify for a fee waiver. That's it. There's nothing to be approved. There's no financial information that's provided, no hearing, nothing like that. And that process works extremely well. The courts, accept it. We don't have, issues with it. And of course, the idea there is that the legal aid program has already done financial eligibility screening to qualify the person for their services. So there's no need to go through that process again in the court to get the fee waiver. The other way that a person can qualify is by receiving certain means-tested public benefits. So for example, if you receive food stamps, if you receive SSI, those are means-tested public benefits. So you have to file an application for waiver of court fees, which is a statewide form. It's a mandatory use form. So the only way you can, get the fee waiver, unless you're represented by legal aid, is by filing this application. And you just say that you received these benefits, and then your application gets approved on that basis. The 2 other ways to qualify are based on income. So one is that your income is below 125% of the federal poverty level. You fill out the application for waiver of court fees, you provide financial information and asset information on that application. A judge reviews it. If you're under 125%, you qualify for the fee waiver. The fourth way is also based on income, and that is your income is above 125%, but payment of the fees would cause substantial hardship to your family based on looking at all of the financial circumstances. Again, you fill out that application for waiver of court fees, provide the financial information, the judge reviews it and approves the fee waiver. Those are for full fee waivers. We also have a partial fee waiver structure, so that if your income is above 125, if you're between 125% and 200% of the federal poverty level, you can get a 75%, 50%, 25% fee waiver. Again, that's all by filing the statewide application for waiver of court fees.
So with the process that they use for folks that have already been determined to be eligible by, or have already had their income reviewed by the Social Security Administration or DHS or by legal aid, is the idea basically, okay, these folks have the time and the resources, they've already done this work, why would we need to duplicate it again in court?
Yeah. Right. So if you're qualifying based on the receipt of those means tested public benefits, the food stamps, the SSI, the idea is that another agency has already gone through a really rigorous review, gathering financial information and determining that you qualify for the benefits. So we don't want to duplicate efforts, right? So the idea is you shouldn't have to provide essentially all that same financial information for the court, just for the court to say, yep, you're low income. So, you can qualify just based on the receipt of those benefits.
So Kendall, what do you think about this certificate thing for legal aid attorneys?
I think it sounds great. I love it. I would love it if all of my cases got filing fees approved automatically. That would make my job quite a bit easier, but I think it would create a lot of, clarity for clients and for the court system as a whole. I may be overthinking things a little bit, but I looked at the form that y'all use, and the only thing I might worry about is becoming, some sort of witness in the case, because, I as a lawyer would have to fill out an affidavit about my client. But, surely rules could be changed to fix that. But I think it's a great system, and I'm glad it's working for you all.
Judge Honorable, I've got one for you.
Okay.
All right, so how often do you see self-represented litigants now in your court? And I know you have a lot of criminal cases on your docket. But
So in January, well, I'll say this just for the benefit of those listening. So when I took the bench in January of 23, I was hearing criminal cases and civil cases. In January of 24, no, I'm sorry, January of 25, I began hearing domestic relations and probate cases in place of the civil. So now I hear criminal and domestic relations probate. Got back to my first love. I love domestic relations probate. And so I saw them in civil cases, and I see them quite a bit in domestic relations cases as well. And I will just say this, I'm always looking for ways to make forms and processes easier for self-represented litigants. And I have found that a lot of how I determine whether that access is really available is, am I speaking their language? And I know I've said that before, but it is so super important, because even people who are high literacy functioning, we still don't speak the same language. From my mouth to your ears, you may hear something completely different than what I said. And many times I find myself asking, would you please repeat back to me what you heard me say? And so in dealing with fee waiver applications, I'm trying to make sure that they understand what's being asked on the form, because sometimes they don't. And sometimes they sometimes they don't know that they're not answering the question because they're answering the best way they know how to do that. And so, but I was like, I'm not gonna require anybody to come to my court and tell me why they can't pay that fee. To me, that's kind of ludicrous, because if you can afford to get to my court and tell me why you can't afford to pay the fee, I've already imposed a hardship. Because I don't know, I just don't understand why that's the case. Kendall, I've never heard that before, but I'm so glad you shared it. So I can make sure and tell my staff, we're never gonna do that. That to me just serves as a barrier. And so I would love to see that process, that consistent process where if your income has been vetted through one agency and they've done the work, we should, I think, collaboratively be looking for ways to remove those barriers. And then maybe it's an affidavit from the petitioner and not necessarily an affidavit or certification from the attorney that says, you know, I am a client of legal aid, whatever, and have the client sign it. And I think that uniform process would be great as well. I love that uniformity, Marisa.
So what about, so we talked about sort of like the more policy side of it, but what about the actual form and what it looks like? And I think you took a look at our interactive form.
I did.
We did a little review of that.
Yes.
It's kind of like a TurboTax setup.
Yes.
Tell me what you think about that.
I do like it. Quite frankly, there are, I think, some questions in the way that it just works that may still be difficult, but I don't know how to get around it. I mean, there are just some things that you just can't get around when you're talking about interactive forms. That's going to require maybe some education on other levels, just on some basic like literacy levels and understanding technology and things of that nature. But in terms of the availability by way of the interactive form and making those questions as simple as possible is really beneficial. It was easy to navigate, and I know there are still concerns about people who may not have access to technology in terms of being able to access forms, but I don't think that's as big of a problem anymore. I mean, people can find access either through their smartphone or through a library or something like that. And so in getting through the form, I was just looking for ways and the questions and the wording of the questions and the ease with which I could get through that form. And I think it works. I think it works. And I think having the ability to print or email it to yourself, I think is also another way to create that access. I would just challenge us all to think about small ways. I think sometimes we get bogged down and burdened down with some of the bigger ways to prevent those barriers in access to justice. But it's like some of the small things that really can create better access if we just think practically. Like I said, going through that form, the interactive form, just puts me in the position of someone who would have to do that and then think about it from their shoes and from their perspective.
Speaking of small things that we can do to make things work better, reduce confusion, Tabitha came up with an idea that was kind of obvious that I can't believe that we didn't already have done. And she said, why don't we put together a legal aid directory? We have the Center for Arkansas Legal Services, Legal Aid of Arkansas, but there's also all these other little organizations that are doing things. So why could we put together a list? So what made you think of that? And then how's that going so far?
Do need to update you on that. So it was a kind of a practical thing for me. I have a 4 and a 5-year-old, and I have a law firm. My law firm is my free time type of thing. So I hate being on the phone these days, but people call me nonstop asking for, which I take it as a huge, people see me in the community as somebody that can give them advice or point them in the right direction. which is great. I just don't have the time to do it. So I find myself all the time screenshotting the helpline information and sending it, texting it to people, emailing it to people. And so, came across a list and with other organizations, and I'm, tired of screenshotting your websites, guys. And so I thought that if we put it together in a way that is accessible for everybody, even organizations, state, anybody that needs to refer, because we cannot help everybody that needs help. And so just even a referral, like the most random issue, like there's places, several law firms that do immigration for free, pro bono, free legal immigration, housing. There's so many law firms that have just kind of their niche or special subject area that they only work on. And that's what people need. They need that special housing, that very nuanced, they have this, again, a legal problem that has gone on for too long without any legal assistance, that has gotten so complicated that they need a housing attorney that only does housing, that's very knowledgeable in that area. And so thankfully we have those kind of, legal aid housing offices and things that specialize in that. And so it would be easier. And so we're working on that. Abby agreed to partner on that, thankfully. And we have an intern that's working on building our kind of contact base right now. So we've contacted everybody that we had on our list that provides either free or low bono or any kind of, clinic style. We've really kind of trying to capture everybody that offers free legal services at all. And so our intern is going through, it's kind of an opt-in process. We're giving everybody the opportunity to say, we're inviting them to be in the directory. If they don't want to, that's fine. We still might refer to them, but they don't have to be, inundated with all of the people that will call once hopefully this resource gets out into the community. So hopefully we are finishing the contacts, and then we'll compile it over the summer and hopefully have it available by the end of the summer in the early fall.
Yeah, and I think something that's kind of maybe not talked about quite as much is obviously there's a benefit, legal aid benefits people, obviously, but it also benefits the court system. And it makes the court system a lot more efficient as I'm sure Judge Honor will tell us. Because dealing with pro se litigants in court can be difficult. I don't know, I'm not a judge, but.
Yes, it can be.
All right, so I wanted to go back to Marisa for a minute and ask you sort of a question that's a little off topic from that, but well, not really, still small policy changes. What is a small policy change that's had a big impact in your work?
One of the things that we have really put focus on is using plain language, and that's a constant process, right? Every time I look at one of our statewide forms, I can come up with a new way we can improve it. But we're really focused on making sure that the information that we're putting out to the public does use plain language. I think our fee waiver application is a good example of that. It used to be called an application to sue or defend as an indigent person, which, is slightly better than IFP, but not much, right? Like sue or defend as an indigent person, what's an indigent? It's just all confusing, right? So 10 years ago, we went through the process of revamping our Supreme Court rule that governs the fee waivers. And we said, let's call this an application for waiver of court fees. That makes so much more sense to everybody involved. So I think, the more we can do that in all different contexts, the better. As the judge mentioned, we're speaking different languages, right? We like to use all these legal terms and legalese, and, using plain language as much as possible, I think, can be really impactful.
Yeah, absolutely. So for our interactive form, and if you guys have pulled these up, not the Illinois one, well, you'll see it there too, but if you pull these up, we do call them fee waivers when we label them, because if we put in Forma Pauperis, people will scroll on by because they don't know what it is. I just wanted to highlight too, I think the last change, and Judge Moore might have to correct me, but I think the last change we made to the IFP form was, it was kind of written in a way to where non-adversarial cases, if you had a non-adversarial case, you couldn't qualify for an IFP. So if it was like an uncontested guardianship, I think, or something like that. And so made a little update.
Yeah.
All right, who's next? I think I'm actually gonna go back to well, you know what? Before I continue with questions, why don't I just go ahead and check and see if the audience has any? Judge Weeks. Oh, here.
Oh. First, thank you all for what is such an important subject. I am in the northeast part of the state, and as a judge, I've noticed that when it's advantageous to the bench for the self-represented litigant to be represented, say, with my parent counsel in a DHS case, or by the public defender in a criminal case, we're very quick to approve them. But when it's in Forma Pauperis, in any other civil matter or whatnot, it's a little more hit or miss, maybe. Do you also see that playing out? Especially with, and not necessarily the folks that are very poor, but I think the larger community of folks that have need for legal services are the folks that are just barely making it.
Yes, I see that, and I'm glad you said that because it brought me back to something maybe Marisa said about kind of in a partial fee waiver situation. So in criminal cases, we have a whole certificate of indigency that qualifies them or not, and there are times when they are not indigent based on the rules that we look at in making that determination. But the statute does allow us to assess a public defender user fee.
Right.
And then it also allows us, and these are in criminal cases, to assess a public defender attorney's fee upon conclusion of the representation. And so what I think though, is there are not enough judges who really use that process. And so in my mind, and I'm not saying this is the only right way, but how I look at that is if there is someone in front of me and they're technically not indigent, but they really don't have money to hire an attorney, I will appoint the public defender, assess the public defender fee. Well, then that money then goes back to a pot of money that then provides financial sources to the Public Defender Commission to continue to provide these services. When you, with a blanket kind of appointment of a public defender without properly assessing whether or not someone is indigent, then you start running into money running out. You run into shortages with public defenders. Well, on the flip side of that, when you're dealing with, say, self-represented litigants in a domestic relations case or in a domestic abuse case or something like that, you still kind of need to use the same lens, I think, but still take into account what can I do as a judicial official to make sure that this individual has that representation covered. And I guess I'll say this too. I've not had a situation where I've say appointed an attorney in a domestic relations case or a DA case. But man, if I could, there would be times I would, if I'm being honest, because sometimes in domestic abuse cases, I'll use that. Petitioners sometimes come in there locked and loaded with what I call a tall building lawyer, and they're ready to go in. And then you got a respondent on the other side who has no clue about what's going on. I mean, yeah, they can figure out the allegations, but there just seems to be an imbalance there. And so you kind of run into a situation where someone has access because they have the funds to hire an attorney, but someone may not. And just because they're accused of committing domestic abuse doesn't necessarily mean that they don't deserve to have a fair shot. And so, I have probably strayed away from the original question, but, that is those processes and assessments in terms of indigency and qualifications, I think are similar, but the way the court is currently structured, depending on the case type, not everybody still is able to get that access. But in every chance that I get, I try to make sure that the playing field is as level as it can get. You're welcome. Thank you.
My name is Paul Calvert. I'm just a regular citizen, but I've had some experience in the legal system for the past few years from my own case. And so one of the things that has bothered me is the filing fee system. It's oppressive sometimes. But when I read the Arkansas Constitution, Article 2, Section 13, it says every person is entitled to a certain remedy in the laws for all injuries or wrongs he may receive in his person, property, or character. He ought to obtain justice freely and without purchase, completely without denial, promptly and without delay, conformably to the laws. When I read that he ought to obtain justice freely and without purchase, that seems in direct conflict with the idea of filing fees. What am I missing here?
I think you're asking some really good questions, and I don't know how to answer that.
I will say this, I'm gonna give you time to get your answer together. I will say this. I certainly understand what you're saying. The way I would reconcile that is the process is available and free. The process is free. But the problem is the access to get to the process. And the access in this case will be the fee waiver. Only issue with that is it's hard to make the system work completely free. I mean, I get what you're saying about freely being able to access and freely being able to sue and defend and all the things. But practically speaking, if you're talking about financially free, that's just really difficult. There's just no way the system would be able to function, which is why I think we're all here, right? We're looking for ways to make it as free as possible, or have that access be given. But that's about as far as I can go on speaking on that, because I don't know a practical way to get around that if you're talking strictly about financial freedom. Yes, Judge Moore, help me out, I'm thinking.
I mean, just a thought. I mean, our judicial branch gets less than 0.5% of our general revenue funding for the state government. And those filing fees, just as our court system is currently structured, our courts are relying in part on those filing fees to fund it. Right or wrong, I mean, I think personally that there's probably a better way to do that. But unless and until our General Assembly makes the decision to fully fund our court system in a way that would allow us to operate freely without, having to find other ways to fund it, like filing fees, I think that's going to be an issue.
Great answer.
Article 2 issue.
I had a question. This is a question for Marisa. I know that the federal government has done the kind of fee waiver process that you guys have, having different tests like the means benefit and the financial hardship, etc. So I wonder, how long has Illinois have been doing this fee waiver process, and what is the feedback that you've gotten from judges as far as like efficiency for the courts and then the reduction or potential reduction of collection of fees?
Yeah, great questions. Many years, well before my time, we've had this structure in place. For the full fee waiver, this partial fee waiver idea, that change to the statute took effect in 2019, so that's newer for us. But this idea of a full fee waiver based on representation by legal aid, receipt of the means tested public benefits, or meeting certain income criteria, that's been in place at least since the mid-90s, but probably before that, if I were to dig back into the legislative history a little bit. We did about 10 years ago go through a process of significantly rewriting the Supreme Court rule that governs fee waivers to update the process. So not the eligibility criteria, but making sure that the process was very clear. And that's when we implemented this mandatory use statewide standardized form so that everybody was using the same fee waiver form across the state. So we've had this process generally in place for a very long time. Generally, I think judges and courts are supportive of it. We still see some inconsistencies in the process across the state. So that's always something that we're working on and trying to improve. But in general, the feedback we get from the courts is pretty good.
Thank you. Okay, so I think we're getting pretty close to the end of the session. Did anyone have any just like questions they absolutely like, I really got to ask this question? No? Okay. Well, then I will. I'll ask one question. Okay, so wrapping up, what's one takeaway you want everyone to get from this? Or I mean, as an example would be, or yeah, let's go with that. What's one takeaway that you would like to leave everyone with?
I think that having a more standardized process for fee waivers that's written in more plain language would be very, very helpful to our community, to our court system, but it would also help people, get justice and due process.
Okay, there we go. Kendall, did everybody hear Kendall? Should she repeat her? That mic's off.
I can. I'll probably summarize. I think that having a standardized fee waiver process would be very helpful, and it would also be very helpful for it to be written in plain language that the public can understand.
Sorry, guys, I'm kind of your eyeball because my practice doesn't use fee, as Kendall mentioned earlier, the fees for filing petitions to seal and clemency applications to the governor for sealing criminal records, there's not one anymore. But my takeaway, I just think the community organizations could also work better together. One of the best partners that I found in my community has been the library. They want people to come in, people want legal help. That's the perfect relationship. And so she allows me there to do free clinics and pro bono week programs and maybe get some kiosks or something like that, a legal help desktop or something in there. But yeah, trying to have better wraparound services for people to access, even if they don't need fee waivers, they would qualify for fee waivers. They still need other legal services. But I think what you guys are doing to streamline the fee waiver process would be great.
So yes, streamlining the process, plain language, and education. I think my takeaway would be connecting with those community partners, resources, agencies that can create educational materials or have in-person opportunities to learn about the process. We were talking about due process earlier. Kendall mentioned procedural arguments and making sure that people's due process rights are protected. I'm really big on that as well. So I think just educating self-represented litigants and understanding they typically don't know, and we have to find ways to help them navigate the system. It won't be as an attorney, but we've got to find a way to give people as free access as we can with the resources and the influence that we have.
I said that was the last question, but I actually have one more for Kendall because I think she was prepared for it, so I want to give her the opportunity. If you had a magic wand, what's the next tool or feature you'd add to further support self-represented litigants?
Thank you, Abby. So somebody mentioned TurboTax earlier, and I'm really glad that they did, because I was thinking, and I believe other states may have this. We have some wonderful interactive forms in Arkansas, and I don't know if y'all have actually seen these, but there are these websites that the mainly, Access to Justice and the legal aid programs have developed. But you go online and you answer questions like you would on TurboTax, and it then like takes your answers and puts them onto documents, PDFs, maybe Word documents in these, standardized forms that people can then file in court. We have a lot of those. I would love it if we had more of them, and if they were like standard forms, approved by the court system for common case types. And then when you're done with them online, if you could automatically e-file them like you do on TurboTax. You answer a bunch of questions, it puts your answers on the tax forms, and then it files them for you. I think that's doable.
See why we had to take the time.
Yes.
Okay,
What's Marissa's takeaway?
Oh, that's right. Yeah.
I am so sorry. I just.
No,
you're
that's
following me. Okay,
That's
now I
okay.
owe you 2 coffees.
No. I think we want people to use the courts, right? We want people to trust courts. We want courts to be a place where people feel like they can come to fairly and effectively resolve their disputes. And I think in order to accomplish that, we need to remove as many barriers as possible. And certainly making it easy for people to access the courts through consistent and effective fee waiver process is one important way to do that.
Thank you. Thank you, Marisa. Thank you, Kendall, Judge Honorable, Tabitha, and everybody with your great questions and your feedback. Appreciate it very much. Megan did mention this earlier, and I'm gonna let her come up and give you some directions. But she mentioned the kiosk that we have set up in is it called the Cultural Center? It's basically to the right out here, up the stairs, and then to the left, which is where we're going to go next. But the courthouse kiosk, yeah, there's information. The courthouse kiosk, they kind of mentioned it, that those are, I think a lot of you folks are familiar with that, but for those that aren't, those are, it's a computer and a printer that we have set up in various locations in courthouses and libraries across the state of Arkansas. And through those computers, you can actually access these interactive forms and other tools to find legal information. So just wanted to give you a little context for that in case you want to check it out when we head over to that other room. Thank you.
Thank you.
Thank you.
Thanks, everybody. Thank you.
All right, welcome back, everybody. Sorry we're getting started just a little bit late. If you are just now joining us, make sure you get one of those teal folders from Tamika. She's right outside the doorway here. This has your attendance sheet in it, as well as a handout Jessica will be covering and the agenda. If you're just now joining us online, I will be sending you the attendance certificate for you to fill out by email by the end of the day. And then you will also have gotten an email from me that has the handouts on it. If not, I will be putting it in the chat for you here soon. So next is our ethics CLE. We're so happy to have you all here. Our speaker came all the way from Denver. And she is right here in the front row, Jessica Fidnon. So Jessica, I'll just go ahead and leave it to you.
Yeah, that sounds great. Thank you. Right. You have my phone, so I can stay on the desk here and not keep you all here forever. Thank you so much, everyone, for the opportunity to talk with you today. I'm not an Arkansan. Sorry, did I get that right? Arkansan, right? Okay, Arkansan. I am not. I'm a Hoosier. So I'm originally from Indiana. I grew up there, went to undergrad there. eventually made my way to Chicago, and went to law school there and then stayed for a really long time. And then about just over 3 years ago now, moved to Denver. So that is where I'm based. And this is, I think, I'll consider this my first time in Arkansas. So super excited to be here. If you have recommendations, I'll be here for another day. So if you have recommendations around town, I will take them. All right, but enough about that. Let's see. Let me just tell you a little bit about my background too, just so you understand where I'm coming from. So I went to, like I said, law school in Chicago. I graduated and hung my own shingle right out of college. I graduated in 2009. Amazing time to do that. Learned a lot, practiced family law on my own, and then I was able to work for a family law firm for a bit, but very quickly recognized that the system just didn't really work. I'll also say I didn't have lawyers in my family, so I didn't have a great sense of what the practice of law was until I was actually doing it. And I decided to go a more non-traditional route, and eventually ended up at the organization I'm at now, which is called ILES. It stands for the Institute for the Advancement of the American Legal System. It's a mouthful, but we are a research center, national independent research center based at the University of Denver. We work across the entire civil justice system. We have 5 different focus areas: civil, judiciary, family justice, legal education, and then the delivery of legal services, which is the focus area in which I work. And then within that, we have 2 projects that I oversee, or 2 initiatives. One I'll actually talk a little bit towards the end of the presentation about. It's called the Above the Line Network. But the most relevant one for today's purposes is called Unlocking Legal Regulation. Oops, sorry. Let's do this right. Hurry up. Oh no. Do I go down? Sorry. Do I just scroll down?
No track with you now. This one.
Yes, perfect. Sorry, thank you. All right, so our initiative, Unlocking Legal Regulation, which we launched in 2019. The reason we did that is because we believe that there are many contributing factors to the access to justice crisis that we're in. I'll talk a little bit more about that here in a second. But we think one of those factors is our antiquated regulatory system. When I say that, I'm really referring to our unauthorized practice of law rules and the various ethics rules that restrict practice. And so since 2019, we've been doing a variety of things to rethink what it might look like if we were to change some of those rules in some way that would allow for additional models and providers to come into the legal profession and build out that ecosystem of legal service delivery. And so we've been doing that a variety of ways at ILES. We host convenings where we bring people together from across the country to talk about the projects that they're launching, create recommendations, things like that. We do some consulting work with a lot of states across the country. We have specialized projects, et cetera. Why is this important now more than ever? Everyone here already knows, and I'll probably not spend a ton of time talking about the need because I think this group is well aware of the need. But add on where we are today, politics aside, I think collectively the profession agrees that the rule of law is being challenged right now. And I think a big part of that is that we as a legal profession just really have let the public down. We have a justice system that's very inaccessible for people. And if we didn't see that before, I think we're really starting to see it now. And so it's really important that we do what we can to try to brainstorm how can we solve this problem. We might have to get a little creative, we might have to get a little uncomfortable, but that's where we're at. So I'm going to start out just talking about a little bit about the need, looking at our current regulatory system, why might we need to change it. I'm then going to spend a lot of time talking about how states across the country are changing the unauthorized practice of law rules to allow for different models and providers and what that looks like. And then I'll wrap up with talking about what that might mean for Arkansas. I am happy to take questions at any point in time. It's a lot of information to cover, so I might move somewhat quickly, but I am happy to stop at any point in time, and then I hope to have time at the end. And I'm here for another day, so I'm also not going to run off right afterwards either, so feel free to stop by and ask questions. All right, so why do we need to rethink our regulatory structure? So this is a slide we actually use in the other projects I referenced, our Above the Line network. We just use it to talk about the market for legal services. And so if you look at the right-hand side of the screen, you see a nice sturdy golf umbrella. It's very, like I said, sturdy, solid, no holes. People underneath it. Oh, I should back up, sorry. So in this picture, the rain, our legal service, our legal issues, and the umbrellas are legal services. And so going back to that hand side of the screen, everyone underneath that umbrella looks really dry. And that's because this represents the high net worth part of the market or the corporate market. So if these folks have a legal issue, they can access legal help. It's not an issue for them. That part of the market works pretty well. If you move to the other side, the left side of the slide, you'll see what probably was a golf umbrella at one point in time, but it looks pretty tattered. Maybe it hit a Arkansas tornado. It's in shambles. And a lot of people underneath are getting wet. Some people are dry, but a lot of people are getting wet. This is meant to represent people who qualify for free legal aid. That could be anywhere between 125, well, below 125%. I know some legal aid organizations, depending on where you are, can go up to 250%. There's a little wiggle room there. But these are the people who theoretically should qualify and receive free legal help. But as you all know, that doesn't happen. We don't have the resources for everyone to get the legal help that they should be getting. And so that is why some people are dry, some people are wet. We also know that roughly 50% of people who experience a problem that has a legal solution don't actually recognize it as a legal problem. So there's a big chunk of people who never even make it to the doors of legal aid or the courts. And then we look in the middle here. When we shift to the middle, just over that income eligibility line and all the way up to the top end of what we'll just call the middle class, we have this middle market. There are no large golf umbrellas here. That's because they're, as we've kind of already talked about today, there aren't a lot of resources dedicated to helping this part of the market, this specific slice of the access to justice gap. You see a couple little umbrellas there. That's meant to represent parts of the market that do kind of work to some degree. A great example is personal injury. So if somebody has a personal injury case, if it's worth a certain value, they probably are going to be able to connect with a lawyer regardless of their income level. If it's below a certain value, and I haven't practiced in this area, but I gather from talking to folks, maybe it's 35,000, 40,000, not sure exactly where that number is, but if your case is below that, you're probably not going to be able to connect with a personal injury lawyer. And then there are parts of the market where flat fees are the norm. And so that doesn't mean people magically have money, but what it does mean is that people have a better understanding of how much their case is going to cost. So if they don't have those fees, perhaps they at least try to get them from other people. So we see that as that part of the market working a little bit better. But by and large, you'll see no umbrella there, and people are getting drenched. But this is also, there is a market opportunity here to some degree. And so when I'm talking about some of the, I'll just call them innovations today, these innovations really are targeting both segments of the market. Some are specifically meant to target maybe this middle segment, some specifically the lower income segment, some a little bit of both. So just keep that in mind as we're moving forward. These stats were already referenced, and actually these, and I have LLC stats too. I saw them on the banner, which is great. And I know you all are very familiar with these numbers. If not the actual stats, you have your own observations and experiences that you can draw from. But a study that my organization conducted back in 2021 with Hill is this legal needs study. It was a national representative study of the population, meaning that it does include all different types of demographics across the country, including different income segments. So this was not just focused on low income, it went all the way up. And so what we know from that is 66% of the population experienced at least one legal issue in the past 4 years. Sadly, only 49%, not even half of those issues were completely resolved. And again, this is the entire spectrum. And then we've already cited some of these stats today. So from the Legal Services Corporation, I think their most recent justice study, justice gap reports from 2022. I just screenshotted a couple charts from that, and both of these reports are online and you can dig into the deeper if you want. But again, as you will see, they also looked at low income. So 125% is roughly $19,000, I think, for an individual. And then if you see the middle segment is 19,000. up to 400,000 or 400%, which I think is like $60-ish thousand for an individual. And then 400% and above. And it honestly doesn't matter even where you look. The numbers are bad for all of it, for the percent of problems for which people sought legal help by income level, even when the problem would have a substantial impact on their life. And then this is just another stat, also really troubling, the percentage of problems for which people did not receive any or enough legal help. So all to say, this problem is well documented. And all to say that this, our system isn't working, right? We do need to change something. Just a couple of comments on a few of the shortcomings with our current regulatory system. And again, I'm largely talking about our unauthorized practice of law rules here, even though that's not everything. We talk a lot about consumer harm. We say that's the reason we have a lot of these rules, is to protect consumers, which makes a lot of sense, except I think we know now, at least to some degree, that is not actually why our UPL rules came back into existence. So the Deborah L. Rohde Center at Stanford Law came out with a paper. They published a paper, I think it was last fall. It's called something along the lines of auto clubs and the lost origins of access to justice. And what it shows is that at one point in time, an earlier part of the 19th century, the UPL rules were largely dormant. There were people like auto clubs who could hire lawyers and help people with legal issues, and got to the point where the bar was feeling very threatened and basically shut it down. And that's how we have these UPL rules again today. So we say it's consumer protection, and do they protect consumers? I think they probably do to a certain degree, although it's a little hard to tell because I'm not sure we really track that very well across the profession. But we also know that there is a large protectionist element to it. And so I think it's worth considering, how does the consumer protection piece compare to the harm that these overly restrictive UPL rules are causing people when they don't have access to the legal system? That is also a harm. So I think we should, collectively just kind of be thinking about those two things. And maybe it's a reason to make some changes. So our current system is overly restrictive and lacks tailoring and calibration. It's not tailored in any sort of way. We have just one rule that basically restricts so many things, where if you were to look, I think, at different case types in different areas, some are higher risk than others. I really think there are opportunities where we could make targeted changes, where we could allow certain programs to exist. But right now we basically just have this very overarching rule, and those rules vary by state, but they're not tailored in any sort of way. It lacks accountability. So we regulate ourselves. It looks a little bit different in every state. Ultimately, it's the Supreme Court, but in some states, if you're a mandatory bar state, the bar is very much involved. I'm licensed in Illinois, so in that state, we had a separate agency that did it, but it was an agency of the court. There's no independent third-party organization that checks that. Again, we regulate ourselves, we call the shots, and that can cause some conflicts of interest, and I think it's a little problematic. I'm not suggesting that we do that necessarily, but I do think it's a cause for us to really think about what is it we're really doing and why. When we talk about the tech piece, which we have had to talk about a lot more recently now with generative AI, we'll talk a little bit more about that here later. But when we think about that part of it, it's very fast changing and it's boundaryless. I know there are a lot of task forces across the country right now that are looking at, do we need to update our ethics rules in light of generative AI, or does that work? Can that evolve? And I seem to see different conclusions. I think a lot of states think what they have is fine, and that's actually my position too, but there are some states that are considering updating the rules to try to keep pace with this, which I think that's a losing battle probably. But also our regulatory rules are state by state, and tech doesn't really work that way. I mean, maybe it works that way if you're a court or legal aid organization that's creating some sort of tech tool to be used. But if you are an entrepreneur, for example, and you're trying to serve that middle market that we're talking about, people who don't qualify for free legal aid, it's really difficult for them to come in and try to create a product or service that will reach the scale needed to be profitable while having to navigate 50 different sets of rules. Really tough. And those rules are really vague. Sometimes they're really hard to understand. They're all over the board. So there's that part of it too. Inconsistent, like I talked about, and then ultimately, in my opinion, this just leads to stifling innovation overall. And then a couple other things I wanted to mention before we start talking about what's actually happening are just some themes and things to consider and some tension points that came up at a recent convening when we were actually talking about AI, but I think it really cuts across all of these regulatory innovations. So one is, again, the purpose and philosophy of regulation. Why are we doing this? Is it really consumer protection, consumer harm, or is it something else? If we are going to say it's consumer harm, maybe we should start collecting some more data about outcomes and think about what is it ultimately the public wants to be protected from? How does that compare to what we think they want to be protected from? They might say, if we had a very open conversation with them, you know what, I'm okay accepting a little more potential harm if I can actually have access. Who knows? We don't have those types of conversations. We just make a lot of decisions for people. Also, this one comes up all the time, which in my opinion, I have called it making the wrong comparison, which is when we're talking about some of the things that I'm going to talk about here in a second. This comes up in tech conversations too. When we're talking about, well, you know, would this be as good enough as a lawyer? Well, first of all, we have no data on lawyers, like human delivered services, pretty much no data. So you can't actually even make that comparison if you wanted to. But also, that's not the right comparison. We know right now the vast majority of people cannot afford a lawyer. And so they're not going to go to a lawyer. Like the alternative or the comparison is no help at all. That's the comparison that we need to be looking at more often when we're having these conversations. It would be amazing if we were to have a world where we're going to get people lawyers, but the math does not work. It's not going to happen in any of our lifetimes. Flat out, it's not going to happen. So I think we just have to sit with that reality, think about these things as we're grappling with how to solve this problem. And then the third one is a little more focused on tech, but and we'll talk about this, but with this has always been the case, but now especially with generative AI, which can do, obviously it hallucinates, it has its problems for sure, but like it can also do more complex things. There's this these big tech companies, they've been essentially, I think, practicing law for a long time. For a long time, you've been able to go to Google and conduct, you know, put something in and it can give you legal advice. Is that the practice of law? I don't know. You know, is technology is not a human. Those are two different things. So if you don't think, like Texas, I think has just said basically like, oh, it's tech, it's not the practice of law. That could be an approach, but you know, we haven't had to confront these types of issues yet. And big tech is there and they're going to continue to exist and do the things that they're doing. It's already happening. And so I think that's just something also that we have to keep in mind as we're thinking through all these things. Okay. So now let's just turn to what I think is the fun part, which is to look at what some of the states across the country are doing. Okay, I'm going to talk about, I think, 4 different innovations, if you will, or strategies that states are taking. But I'll just say at the outset, you know, if Arkansas wanted to adopt any of these things, one, just know that there are already states doing these things. So it's not like you would need to start from scratch or I'm sure some of these ideas are going to be uncomfortable to people, and that's totally normal. That happens all the time in these conversations. What I would say is if you hear something and you're not excited about it, maybe you're feeling uncomfortable, maybe you're worried about consumer harm, I totally get it. We want people to be protected. We don't want them getting bad advice. But, and also say too, we're all trained to do that, right? We're all trained as lawyers to identify risk. That's why we exist. It's a very important skill. But what we also need to do after we do that is find a way to get to yes on some of these things. So feel uncomfortable, identify why that is, and then also ask yourself, but how could I potentially get to yes with this project? Maybe it's certain changes. Maybe these are customized to Arkansas. They will be customized to Arkansas. So I'm just challenging everyone to keep that in mind as we talk through these things. Okay, so one innovation is the Utah Sandbox. Raise your hand if you're familiar with this concept at all, just so I know how much to talk about it. Okay, a few people. Sweet. So I could probably have an entire presentation on the Utah sandbox. So I'm going to share some overarching information on all of these different approaches. And then if you want to come back to any of them, I'm happy to answer questions at the end, or like I said, I'll be around and I'm happy to send more info, etc. So the Utah sandbox, this launched in August of 2020. And what is a sandbox? Basically, it's a regulatory structure in which you relax rules. In this situation, what the Utah Supreme Court decided to do was relax the rules of unauthorized practice of law, and also Rule 5.4, where allowing people who aren't lawyers to share an ownership interest in a law firm. That's what they've decided to do. You could create a sandbox where you relax different rules. There's no certain thing that you have to do, but in this particular situation, that is what they did. And the idea there was kind of like I was talking about with the ILS Unlocking Legal Regulation Initiative. It was, if we relax these rules, if we allow other categories of providers to come in, other types of business models, maybe people who aren't lawyers own law firms of people who are, or law companies, what would that look like? Would that actually increase access to justice? So that's kind of the hypothesis, if you will. And like I said, it launched in 2020. It is a 7-year pilot project. And to my knowledge, it is still a 7-year pilot project. Initially was 2 years, and then they very quickly realized that 2 years was not enough to actually assess whether that was happening. So they very quickly actually extended it to a 7-year pilot project. I will note here that we at ILS are the independent third-party evaluator for the sandbox. And so we'll be coming out with an interim evaluation report. It's a process and outcomes evaluation, hopefully in the next month or so. So be on the lookout for that if you're interested. And then what we're also doing is conducting a social return on investment analysis of the sandbox, which basically means we're just not looking at how much it costs to put on the program and any financial outcomes, but we're also looking at other types of outcomes. How did it otherwise positively or negatively impact the community, the justice system, et cetera? So it really takes a more holistic view of that. And I don't know if I can do a better job explaining it than that. We'll just have to look at it and see what it says. I haven't seen the final version of that part yet. So be on the lookout for those 2 reports if you're interested. And then our goal is in 2027, which would be at the end of the pilot project, to go in and conduct a final evaluation. And I'm not sure what that looks like yet, because the court has made some changes, especially recently, and they continue to make changes to the program as they collect more data. So we'll just have to see what that looks like. But how does it work? If you are an entity, whether for-profit or nonprofit, and you have to apply to the sandbox, they review the applications, they have certain requirements. If you are admitted, they then they kind of assess the risk of your entity, and based off of that, they determine what kind of data you need to report on. They could also do things like conduct audits. So they have various tools that they use depending on the entity, but it's customized to the entity. So it's just not a free-for-all, but it does allow for this more creative space where you can try stuff out, but they are going to monitor you and collect data. And depending on what they learn, they could ask you to leave, and they have asked entities to leave, especially recently. They're learning a lot, and they now have a better sense of what types of innovations they like and think are having the most impact and which ones aren't, and they're making changes based on that. So this is just one model that some states are using. Just of note, Utah was the first sandbox, but there are other states that are exploring sandboxes right now as well. So for example, Washington State announced that they're going to start, they described it as an entity regulation pilot project, but it is essentially a sandbox. I know that they're working on that, and I think they're right now targeting the fall to launch that sandbox. I think the way it's going to work is companies, again, can apply. They have to have an idea in mind that they have to submit. And I think they likely will have to have a plan as to how they're going to measure that. But I don't have a ton of details on that one yet. I think they're still working through those types of details. So we might see another sandbox there. And I think their sandbox might have a large technology focus to it as well. There's also the Minnesota State Bar. There is a committee well, I think the court has already approved the idea of a sandbox. The reason they want to create a sandbox is they want a specific focus on generative AI. And so all of the organizations, whether again be for-profit or nonprofit, that apply to operate in this sandbox and with those relaxed unauthorized practice of law rules, they're going to have some sort of generative AI element to their delivery of legal services. And they're also right now in the process of trying to figure out exactly what that's going to look like, but they're working on that right now. And then Indiana, I will mention, has recently shared that they are going to be launching a sandbox, and they're kind of using a different meaning for sandbox. It's not going to look quite like Utah, Washington, or Minnesota. Instead, their sandbox is focused on, I think they want to focus on like nonprofit law firms, combining nonprofit law firms with like licensed paralegals and community justice workers, which I'm going to talk about here in a second. So point being, sandbox is a pretty general term. And if you were to launch a sandbox, you could make it whatever you want. But it's just an experimental space where entities are still regulated though. Oh, and in Utah right now, I think I have on here 12 authorized entities. I think it might be closer to 16. Like I said, Utah right now is reassessing sandbox. They have been since September. They're in what they call phase 2 of the project. And so these numbers have been fluctuating. At the high point, I think it was at like 60 entities. And like I said, they have been asking some of those entities to leave, namely the ones where it's lawyers and non-lawyers owning law firms together, and then there's no other innovation. So if it's just that, they've determined they're not as interested in that. They would like to take their very limited resources that they have to regulate and focus it on other types of entities. And I can answer questions around that if you're interested. Okay, so those are sandboxes. Another innovation or strategy is allied legal professionals. And just want to make sure I'm hitting all my points on these things. So our organization, ILS, actually has a project specifically on allied legal professionals. So we have a little more information on this than some of the others, but the term allied legal professionals is one that we have created and used at ILS to describe the different types of programs, which are essentially licensed paralegals or paraprofessional programs. And I'll talk more about this, but there are 7 states that have these programs and they all have different names. They all call their allied legal professionals something different. So actually some of the work that we're actively doing right now in this space is to bring those 7 states together and then also conduct focus groups with the public in those 7 states and try to find a title that resonates with the public first and foremost, and then can be uniform across the 7 states. So right now, none of these states call their programs allied legal professionals. This is kind of just what we call it to talk about this category of providers. And if you think about the medical profession as an analogy, we have doctors, we have lawyers. The medical profession, you have nurse practitioners. This is kind of where we see the allied legal professional being, is kind of like the nurse practitioner of the legal profession. And so they're not lawyers, but they still are getting substantial training, and they're ultimately certified or licensed to offer legal advice, legal assistance in a narrow scope of work. And so, for example, in these 7 states, I think all 7 states allow their allied legal professionals to practice in the area of family law. A lot of states go beyond that. There are several states that do family law, landlord-tenant, consumer debt. Those are usually like the 3 highest need areas. And so a lot of these programs will start. And then in Arizona, they've expanded it even beyond that. And I think in Minnesota, there are some differences about these programs. In Minnesota, these individuals are supervised. But in Minnesota, they recently added estate planning and probate, for example. And so I think what we're going to see is these states continue to add practice areas as they build out these programs. But like I said, 7 states, so Washington, Oregon, Utah, Arizona, Colorado, we just launched our program about a year ago, Minnesota, and then New Hampshire. In New Hampshire and in Minnesota, the allied legal professionals have to be supervised by an attorney. So they cannot operate on their own. They must work for a private law firm or a legal aid organization, but must have that attorney supervision. The plus side to that is that it's faster to stand up a program because you don't have to create separate licensing. I mean, to some degree you do, but you don't have to do all the things that you have to do with these other more independent programs, which we'll talk about here in a second. So, like I said, Minnesota and New Hampshire, they have to be supervised. And Minnesota has put out a couple reports with some data on their, I don't know what they call them, their allied legal professionals there. All the other programs, they can either work under an attorney or they can hang their own shingle and operate on their own. We prefer, or we're of the opinion that allowing them to operate on their own is a good thing. It just gives people more opportunity to go out and set their own fees, for example. And then also we think then there might be more of an opportunity to upskill people who are already in rural areas to get this training and just operate from where they are, as opposed to possibly having to move somewhere else where a licensed attorney is. So we think it just gives people more flexibility, and the data showing that there's no more risk of consumer harm with people who are not supervised by an attorney. So at this point, I think if you added up all the different ALPs from the 7 programs, I think we're at just under, I think it's just under 400 total. 388, no, sorry, 338. So just over 300 total ALPs. And I think we're going to see more states come on board with these programs. I should have mentioned at the outset, so our organization has a knowledge center on our website where we track information about all these different programs. And so we try to track and curate all the updates about the Utah Sandbox. We have actually a special knowledge center because we have a project on allied legal professionals that has all the information from all 7 programs. And every time any one of these programs publishes a report or anything that would seem helpful, we track that on our website. So if you're interested in learning more, you can go, this is basically a snapshot of the Knowledge Center for Allied Legal Professionals, and you can take a deeper dive on all of these things. And so we talked about the scope of their work, practice area scope. If we talk about the actual work itself, what can these folks do? They can offer, I should say there are slight variations across states, but for the most part, they can, they can all offer legal advice in every state. They can help fill out forms in every state. They can talk with opposing counsel, they can negotiate. Where you see the variations come in oftentimes is with respect to court. What can they do when they're in court? There's a range there. So in Arizona, they can pretty much do everything that an attorney can do. And in some other states, it's a little more limited than that. So yeah, that is that group. I will say, as far as education and licensure goes, we have all this on our website too, but fluctuates a little bit, but usually you can qualify to, usually you have to take what essentially looks like a mini bar exam. And in order to qualify for that, there are different education pathways. And especially as programs start out, sometimes they will really take into account, I'm sure we all know this, a paralegal who isn't really maybe technically a paralegal, but just has so much experience and maybe is even better than some of the attorneys that we know. There's credit given to that. So they're thinking about those things too. So you'll see the states have different pathways to actually sit for that exam. And then the exams themselves are essentially little mini bar exams, which we're not a fan of because we don't think the bar exam is actually a great way to test competency. But do know that these folks are just not like showing up and just like doing whatever. Like it's actually hard to become an allied legal professional in a lot of these states. There still are substantial, like I said, education requirements. Usually there is a practical requirement as well, a certain number of hours that you need to complete. And oftentimes a certain number of hours like in the particular practice area. So there's that component of it too. And then, like I said, you have to sit for the bar exam. There's an ethics exam, I think in all 7 states. And then on the back end, it looks very much like an attorney. They have to get CLE. They're regulated in the same way. With respect to malpractice insurance, I'm trying to think. I think Oregon requires its attorneys to have malpractice insurance, and so it also requires its ALPs. I want to say Washington State does as well. But the other states, I think, have taken the position that they have with their attorneys, which is they don't require it. They recommend it, but they don't require it, which I think is the case in a lot of states. So that is like I said, the allied legal professionals category of provider. Just looking at my notes here to see if there's anything else. Oh, I wanted to share too that this category of provider was developed with really that middle market in mind. It doesn't have to be, like, you could have allied legal professionals that work at legal aid organizations and expand service there. That makes a ton of sense. But the idea was we need to be finding more market-based solutions as well. And so a lot of the allied legal professionals really are targeting people who are above the income eligibility line. But like I said, there is flexibility there. And like I said, in Indiana, their very focused goal, at least at this point in time, is to create nonprofit law firms that really utilize allied legal professionals. So we will see how that goes. It'll be interesting. Okay. All right. Community justice workers or community legal advocates. Has anyone heard of this category? And I didn't ask about ALPs. Maybe raise your hand for that one too. Okay, we have a few people. Awesome. Sweet. Okay, so this is another category of providers that has been coming on to the scene over the past couple of years. And so if we kind of go back to that medical analogy, we had doctor, nurse practitioner, community justice worker in my mind comes below that. So I don't know if that would be a nurse or if it'd be some sort of technician or like a specialist down here. I think there's probably a wide range, but that's kind of what we're talking about. That's the equivalent in the legal profession. So we have lawyer, allied legal professionals, and then in my mind, these community justice workers or community-based legal advocates sit kind of like right below there. These are largely targeting low income. These are typically folks who are already working at a community-based organization. It could be a legal aid organization, but it doesn't have to be. It could be a housing organization that maybe doesn't actually have lawyers on staff, or maybe they do, but it's not technically a legal aid organization. It can look a variety of ways, but the point is that the idea here largely, but also this could look a lot of different ways depending on the community and the need. But what we're seeing so far is these are typically folks who are already working at these organizations, are already getting paid by these organizations. This is an opportunity for them to be upskilled and certified so they can offer very targeted legal advice and assistance. And so if you think about, we see these a lot in housing organizations, but they could be in a lot of different places. But with a housing organization, for example, what we've seen is these folks will be trained to offer limited legal advice around eviction cases. And maybe limited legal assistance. Maybe they can help people fill out forms. Maybe they can assist them in the court. Maybe not talking to the judge, but maybe they can sit next to them. There are a bunch of different ways this could look. But the idea is that when people are already coming to these trusted community members, it's allowing them to do the things that they already want to do and probably can do. And would be able to do if we actually just gave them that training and then certified them. And then from there, they look a bit different. If they're a legal aid organization, there's a little bit of attorney supervision there. In Arizona, their models, and Innovation for Justice is the organization that's really taken the lead. They had the first actually program that launched in 2020. They have a variety of programs in Arizona and through the Utah Sandbox. And their model is a little different. Their community-based advocates do not work really at legal aid organizations. They work at community-based organizations, and they have figured out a different way to train and mentor and supervise them. And then Frontline Justice is a national organization that really is taking a model that they started in Alaska Legal Services Corporation started their model. And so their model really is legal aid based. I think there are pros and cons to both. One thing with the legal aid model is just oftentimes there are restrictions with legal aid about who you can and cannot serve. So if you're wanting to think about, something a little more holistic, that's just something to keep in mind. Maybe you have both models or one model in one community, one model in another. I don't know. But just know that there are different approaches, and this seems to be really popular, I think, for a lot of reasons. I think that when leaders in states are thinking about what they can do, maybe realizing that they probably need to do something and start somewhere. I think a lot of them start here because I think it's low-hanging fruit, in my opinion. So we have seen this become very popular over the past couple of years, and you can just see all the different states that are listed there at the bottom. I might not even have a complete list. Frontline Justice does have a map on their website of all of the reform work that they're doing. And then, like I said, Innovation for Justice is doing a lot of work in Arizona and Utah. And I know that they've been working with folks in Indiana that's looking into this right now as well. So a lot of enthusiasm in this space, and if this was at all interesting to anyone in the room, I'd be happy to connect you with one or both of these organizations just so you can start getting more ideas. All right, let me look here. Let's see, as far as numbers go, hard to tell. When I've heard Frontline Justice talk about at least the work that they're doing, I've heard them say several hundred in the pipeline. I'm not sure how many are, I know in Alaska, they definitely have probably like 50 to 100 people who are actively working. I'm not sure where these other states are at in the process, but I know they have a lot of people in the pipeline. And like I said, we're seeing a lot of these in housing. In Arizona, they have, well, they're just changing the title, but they used to be called domestic violence legal advocates. They have medical debt advocates in Utah, also housing, also domestic violence. So those are kind of the big areas. Oh, public benefits is in there too. And public benefits, you don't actually have to have UPL reform. That's something you could actually just start with right now. And actually that is where Alaska started when they were creating this program. They actually built out a program around public benefits because they didn't have to get any sort of waiver from the Supreme Court. And then when they had that system built out, they started to expand into areas where they actually did need to have a UPL carve out. So that's something to think about. And I should also mention here that Innovation for Justice has a great spreadsheet that actually has, as best as they can keep track of them, like the various components of each state's program. So you can see how, like administratively, how they made this change. You can see how they're educated. You can see how they're certified, those types of things. Sorry, just should like get rid of this by program. So if you want me to send you a link to that, I absolutely can do that. Okay, so that is that. Let's keep going. I just wanted to mention this. I don't know that we need to take a super deep dive into litigation, but you should be aware that some of the strategies that some states have had to take is litigation. So they've tried to work with leaders and just haven't really gotten any traction. And so they have decided to sue and see where that goes. And so there may be more cases than what I have on the screen, but these are the four that I'm the most familiar with. And you might be familiar at least with the Upsolve case. But these cases are all very similar. These are essentially all First Amendment cases, essentially saying that, and what these people are, what all of these groups are trying to do is just train people to help people fill out forms. That's it. Kind of crazy that we actually have to sue people over this. Like, if it's wild to me that we have, and we've had a whole discussion about this. It's wild to me that we haven't created forms that people can just use on their own, understand how to use on their own, and we actually won't let people train people who aren't lawyers to help people with forms. Wild. That is really what all of these cases are trying to do. So the Upsolve case, for example. Upsolve is a organization that has created bankruptcy software. I've been told it's really awesome. They're a nonprofit, and they were trying to train essentially like justice advocates to just help people use their software to file forms. That's it. In the second case in North Carolina, same thing. These are two paralegals who are not lawyers, who just want to be able to help people fill out forms. South Carolina, same thing. The NAACP was trying to, again, train advocates to help people in eviction cases fill out forms. And then the veterans situation, slightly different in that this group was charging for their services, but the same thing is helping people fill out forms, is giving them information. Is this First Amendment? Is this free? Is this speech or is this conduct? That's what a lot of these are looking at. Upsolve, they won at the trial level. That case is currently on appeal. In North Carolina, they lost. The paralegals lost. That one is also on appeal. And the Institute for Justice is the organization that is representing Upsolve and the paralegals. South Carolina, there's a lot of procedural history there, but ultimately the Supreme Court there decided to approve that program. So they won, which is great. I'm not sure of the status of the program, but they now It was very targeted, right? They didn't approve it for everyone, but that one particular program, they're allowed to operate and do that. And in the veterans case, I think they've lost at the trial level, and that one's on appeal too. So I think a lot of people are watching this. They're really curious to see what happens next. If a lot of these folks win, that's going to be really interesting. All right, and then I just wanted to touch on really quickly this slide and a convening that we held in November. And so getting back to technology and AI, like I said, there are a lot of task forces that are popping up across the US that were evaluating whether the ethics rules needed to be changed with respect to how lawyers practice law. There weren't, though, a lot of task forces, or we weren't seeing as much conversation around the delivery of consumer-facing services. Should it be allowed? Should we regulate that in some way? Do we need to change our rules in some way? What do we do with that? We weren't seeing a lot of people talk about that, but we think it's a pretty big deal because we could really leverage AI. I mean, tech's been a thing for a while, right? We've had these conversations, but again, now that we have generative AI and it can do some pretty incredible things, there are risks and challenges for sure. So we did it. We talked about those things too, but what should we do with all of this? It seems like we should really rethink our rules, because what we really want, as what we were talking about as a group, but I would imagine what everyone in this room would want 10 or 15 years from now. We're trying to imagine, like, what do we ideally want? I think we ideally want this to work. Like, I think we want generative AI to eventually get to a place where we can build these tools for courts, legal aid organizations, the middle market. We want this all to work, but in order to get there, we are going to have to make some decisions and some changes so that we can actually experiment to some degree and eventually get there. And so that's what the conversations were about. We talked about some of those tension points that I talked about, the shortcomings, all the things. It wasn't just, all pie in the sky. But what we ultimately decided is that a lot of ideas were generated. We at ILS just kind of grouped them into this two-phased approach, which was the first phase is recognizing we still have a ton to learn. And this report should come out in the next month or two as well. So it captures all the conversations that we have, and it goes into greater detail about these things that are on the screen right now. But there's an acknowledgement of we still have a ton to learn, and we even listed out a bunch of questions that we would ultimately want to learn or answer. But in the interim, we also knew that we couldn't just not do anything. And so in that first column, it was really just brainstorming ideas around what can we do kind of in this with soft power in this first phase that is undefined. I don't know how long phase one lasts, but let's say it's a year or two, I don't know. But what can we do in phase one just to kind of get this moving along? And so not surprisingly, creating best practices and clear guidance for the people who are actually developing those LLMs, deploying them, and then ultimately the consumers. We talked about a sandbox could be a space to experiment and learn. And so that's where Minnesota comes in. One thing I'm going to skip down, one thing that we're exploring in Colorado, I sit on a committee there, is this issuing prosecutorial guidance and no action letters. I don't know that our regulator will do no action letters, but we are trying to come up with guidance, a policy, if you will, that essentially at a very high level says, if you meet certain criteria and you don't do certain things that are bad, then you're going to be very low priority for us, even if we think you're violating unauthorized practice of law. So it's kind of interesting. I didn't even know something like this existed. So that's something that we're working on right now, but we're pretty close to having something. And I think that could be really interesting because, like I said, you're not making a rule change necessarily. It doesn't require additional resources from regulators. And I know resources are, we don't have a lot of resources or extra resources to give. So that could be an interesting approach. But like I said, the report will outline in greater detail some of these different options. And then you'll see on the right, phase two, this is basically after we've answered a lot of these outstanding questions, and based on everything that we learned, do we need to do something more permanent? Maybe not. Maybe we're good at where we're at. We're not sure. But the point being, in that second column, it lists out some more permanent programs or changes we could make. So maybe we would actually make a rule change. Maybe we would come up with some sort of certification process for tools. I think that's a really interesting idea. It would take a lot more resources, but you know, like I said, maybe after phase one, we decide that that is important, and so maybe we go that route. And the only other thing I'll just mention here really quickly is that, again, going back to big tech, we talked a lot about that. You know, is someone like ChatGPT, who I think is very clearly practicing law, they're not holding themselves, to my knowledge, out as lawyers. Maybe that matters. But what do we do about with them? What do we do with them? Can we practically regulate that at all? You know, can we have some sort of strategy where we try to work with them? So we talked about that too, and what that could possibly look like. Okay, and then I just threw this in here. So this is obviously just taking the first slide, and I don't think I have all the different models and providers down there, but just trying to show what a more expansive ecosystem might potentially look like. I did try to slot the different innovations under where they would fall in the umbrella, or I'm sorry, in the spectrum. Okay, so finally, what does this all mean for Arkansas? Could mean a lot of different things. So we really are finding that these models are expanding access. We don't have a ton of data, but we actually do have some data from some of these programs. There's an evaluation done on the Washington, I'll just call it their Allied Legal Professional Program. It's actually called LLT. Excuse me. There was an evaluation done by the Rhode Center in Stanford on that. It has a lot of really interesting information. I recommend checking that out. Like I said, Minnesota and Arizona have annual reports now that include some data. And if you look in there, you're not going to see a lot of complaints. I don't even know if there are any complaints in some of them, to be honest. Like, it's so minimal. Same thing with the Utah sandbox. We're talking minuscule. So we are starting to see some data. And I know we are in talks with the group in Colorado to start working, hopefully at some point soon-ish, on an evaluation there. So we are starting to get, like I said, more data. In the community justice worker space, I think the best folks to talk to would probably be, well, really both Frontline Justice and Innovation for Justice. They both have not necessarily published data, but they're very much on the ground, and they could tell you, answer all the questions that you have. And it's kind of the same thing from what I've heard there too, like not seeing any huge uptick in consumer harm. Are there changes that need to be made, and are there changes being made? Absolutely. We're learning a lot every day, but the programs seem very promising. And like I said, you can take the best of these programs and you can look at your situation and you can customize it. There's so much opportunity to do that, and they're so willing to help. So let's see. These models will help you serve underserved populations. We also think, especially the allied legal professionals and the community justice workers, can help in more rural parts of states as well. Again, the idea there being, instead of trying to get lawyers to move to more rural parts of the state where they're not from, it's proven to be very challenging. I don't think not just here, but really across the US. A lot of states have legal deserts. And instead of doing that, it might make a lot more sense to try to create programs where you're upskilling people who are already there. They already live there. Maybe they don't want to be a lawyer for a variety of reasons, but maybe they want to be a community justice worker. Maybe they want to be some sort of licensed paralegal. And then maybe at some point they will want to be a lawyer. But if we can start creating those systems and those pipelines, that's something that I think might actually be more promising. Definitely not saying like stop all these other efforts. And we have a lot of efforts in Colorado that are working to some degree to get people into more rural parts of the state, but it's the numbers are very small, and we're going to need more. And going back to that ecosystem slide, honestly, like we need all of it, right? The gap is so big, we need all of it. But it doesn't mean you need to do all of it at once. I just really encourage this group, and I encourage every group that I talk to, just pick somewhere to start. You're probably going to end up having to do all the things, but just pick the place that makes the most sense for you right now, and then you can slowly build out your ecosystem. I have on here, allied legal professional models can be good for business too. So in Colorado, for example, you know, our licensed legal paraprofessionals can either work for a firm or they can work on their own. It's the same in Arizona, and we're seeing, especially to start out, a lot of them are working at firms because that's where they were when they started, right? They couldn't work on their own. So it makes sense that that's where they got their education. We're finding a lot of law firms are actually paying them to get the additional education and certification, which is really great. So a lot of them are starting out in law firms, which makes sense. And what the law firms are saying is that it's allowing them to serve a new group of people. They're being able to bill out these professionals at slightly different rates than lawyers, and that expands the number of people that they can serve. So there is that. Like I said, next bullet point, no need to reinvent the wheel, although you absolutely can, and if you do, please tell me. But yeah, there are a lot of resources that already exist. It might sound overwhelming to think about a community justice worker program or an allied legal professional program and having to build out all those things. I'm not saying it's not any work, but there are several states now that have done these things. And you can very easily just take their work as a starting point, and hopefully it will reduce the amount of work you have to do. And then, oh, I did want to mention here too, a starting point could also be legal first aid. So again, using that medical analogy, now we're going all the way down to the bottom, legal first aid, legal information, okay? There's an organization in the Bay Area called Legal Link. This is what they've called their training program. And they are now working with Oklahoma and South Carolina and probably some other states that I'm unaware of. I think actually this is the approach that we're going to take in Colorado with respect to community justice workers, because we want those too. But I don't know that we have all the support we need for this program quite yet. But I think the plan is that we're going to build out kind of the network and the foundation for legal first aid across the state first. And then once you have those partnerships in place and you understand what the needs are, it should be much easier then to figure out what are we going to certify people to do, build out those training programs, et cetera. So that might be where you want to start. Who knows? You have a lot of options. And so final thing, because I work at a research organization where we both research and evaluate, this is really important. If you're going to start something, it's super helpful, especially if you want to evaluate down the road, to think about it at the outset. Have your program objectives and think about how might you evaluate that, and then what systems do you need or processes do you need to put in place to actually collect that information. We have a really great blog post on our website that kind of outlines some ideas for this, but this is something we're always happy to help people with, because it's really difficult to go in and try to get some of this information partway through, especially when certain expectations maybe weren't set and you don't have the data. So just something to think about. Sorry, I'm a mess. Okay. I'm going to take questions, but really quickly. I said I wanted to mention the Above the Line Network, so I'm going to do that in 30 seconds. But one other project that I oversee at ISLES, it's called the Above the Line Network. And it is specifically focused on serving the middle class. And so it is a group of people from across the country, all different stakeholder groups. We're coming together and working towards developing solutions for that particular group. We use a very expansive definition right above the income eligibility line. I know that's not middle class, but we want to capture that group. So it's that group all the way up to what Pew defines as the top of middle class, which is $110,000 for an individual. So it's a free group. I do have a flyer up here with more information and a sticker, because that's what we do in Colorado. We put stickers on everything. So if you're at all interested in that, come up and see me. I'll give you some information and we can talk more. But thank you so much.
Does anybody have a question?
Really quickly, you
Yeah.
mentioned with the field A's, do you know if they work with community, like churches or faith-based organizations? I can see that being maybe a good partnership, and if they set their own type of rate, since they're trying to kind of reach the justice gap.
Yes, I know for sure in Utah, Holy Cross Ministries is involved in the medical debt community legal advocate program. So yes, they absolutely can be involved. And then they get to set their guidelines. They can decide who they want to take. So if they want it to be free, if they want to charge some, small fees, that's up to them. Good question.
Thank you so much for your talk.
Yeah.
So I work in immigration, and I was thinking about, are there any useful parallels from federal administrative agencies like the accredited representative program?
Yeah.
I think I saw some comments about Social Security, and there might be some good sort of long-term data for those, because I think some of those are pretty old. So can you talk about any of those parallels?
Yeah, I'm glad you brought that up. I meant to mention that in the allied legal professional space, because oftentimes people are uncomfortable with that idea. And the fact of the matter is that there are these accredited representatives in the immigration space, for example. But in other areas too, in these federal areas of law where they've been practicing for decades. And from what we can tell, it's again, no increase in consumer harm. It seems to be working quite well. We should have more of them though. I hear some frustration in that group that we could have a lot more accredited reps, so how to really increase that pipeline. But we've talked with the accredited reps and it's definitely, you can create a thriving business around it, which is really great. You're helping a lot of people. We don't have, there are a couple, Amy Wiesman, I think is her last name. She's a professor at Rutgers. I know she's done a lot of research on federal administrative hearings and to some degree to the extent that she can state administrative hearings. And I know she's been working on, I think in Chicago and one other city, and is going to have some interesting research come out about that. But she's someone I would research if you want to know more about that. But beyond her, there isn't a ton of data, but again, we've had these systems in place for decades. I have to imagine if they were really, really bad, we would shut them down. Maybe. I don't know. Talk with people on the ground. It doesn't, I feel like when I was in Chicago, the National Immigrant Justice Center said a lot of good things about them. That's my reference point. So I hear good things, but I'm not going to lie and say that we have all this great data because we're trying to collect it. And Amy is actually working with ACUS on a project. So hopefully we'll have more. Yeah, good question.
One more question. Okay. Yeah, did you guys create a special board to provide oversight, or is it the Office of Professional Conduct that provides direct oversight for these programs?
So for the allied legal professionals programs in the different states, it's usually whoever is licensed. Well, let me think about that for a second. I think it's oftentimes the same organization or body. Maybe it has separate person, but I think it's usually the same body that is licensing and overseeing lawyers. So I know that looks a little bit different in every state. And the community justice workers. In Alaska, I think Alaska Legal Services Corporation is taking the lead on that, and they're the ones providing the education and the certification. And so since frontline justice model is largely based on that, I would imagine that is similar for some of the other states that are adopting that particular model. In Arizona, it's through the Office of the Administrative Office of the Courts. I think does the certification and maybe keeps track of it. I think they do. And then in Utah, it's a little more complicated. So right now in Utah, these groups go through the Utah Sandbox. And so because you have entity regulation in the Utah Sandbox, the way it's kind of working is that the organization itself, or there have been these like an umbrella organization created that kind of is like the certifying entity. And they're the ones who ultimately certify, and that's how they get licenses through the Sandbox. So there are different mechanisms. That one's a little unique. Yeah, and I'll mention too, like I said, on our website, we do try to post like the administrative orders and or the documents that explain kind of how this happened in each state. So it looks a little bit different. Good question.
Does the paralegals appear in court?
Some of them do, yeah. I think all of them do actually to some extent. So the supervised ones in Minnesota and New Hampshire, I'm a little less familiar with New Hampshire, and their program in New Hampshire is teeny tiny. It's like 3 people. So, but in Minnesota, it's a little bit bigger. I think they have about 30 LPs, or I'm not sure exactly what their title is there. They are supervised, and their attorneys can go to court. And since, like I said, it started out in family law, they've more recently added additional practice areas. But it's in family law, they can do, I believe, the full range because they have that attorney supervision. In Arizona, it is pretty much the same way. I think their LPs can also do the full range, but they can do it on their own. In Colorado, I think ours are slightly more limited. They can't handle There are certain carve outs about the cases, not a ton, but there are some carve outs about some types of family law cases that they cannot take, and then in court. I have to look on our website, but it's a little bit restricted. They can't do the full range, but they can do quite a bit. So, I mean, that's something you could customize, and you can also always start with something and then expand.
All right.
Who's excited to start a program?
Just, are law schools involved anywhere with 1Ls and 2Ls? I know we always have students that, you know, want to get engaged, aren't yet, and we worry about Yale stuff, but are any of these programs involving
Lots of students. So Innovation for Justice is actually out of University of Arizona. So they have involved law students in the creation of a lot of their innovations. But they're not, I don't think that they're necessarily like the advocates themselves. And I'm trying to think. I don't know, there's just so much more room for opportunity for law schools, I think, to get involved. The answer probably is yes to some small degree, but I don't have to think about that one. They could be though.
Okay, I think we should wrap up unless you guys want to stay here all day.
Sorry.
No, you are fine.
Okay, so thank you again for joining. Thank you again to our speakers and our sponsors for volunteering your time and knowledge. We really appreciate you all. So this was my first joint board retreat to plan, so hopefully it went all right. If you hate it, I have no hand in it, and your complaints to Abby. So if you're with the board, we are having our lunch in that room where we had our break, and all our other meetings will be in that room as well. Let's see. Everyone else, again, glad to see you. Don't forget to turn in your attendance sheets to Tamika, who's outside at the table. And if you're on Zoom, I will be sending that to you by the end of the day through email. Abby, did you want to say anything?
I got one quick thing to say. I'll just throw this out there. For anybody who's not on the commission or the foundation who's here today, if you're interested in this, if this is something you want to work on, whether it be what Jess was just talking about, or something having to do with updates to the informal Pauperis rule, come talk to me, because there might be some room for you to help out with that. Thanks.
I'll